Good morning, everyone. Today I'm going to discuss some of the features of international criminal law and also relationship with the human rights and humanitarian law. See, there are certain principles and modes of interpretation in the international criminal law. A primary method, like of interpreting the interpretation, to interpret the international criminal law, which is stated in Article 31, Clause 1 of the Vienna Convention on the Law of Treaties, is that a treaty should be interpreted in good faith and according to ordinary meaning to be given to the terms of a treaty in their context and in the light of their object and purpose. That means you see that all of us know that while studying the public international law also and in international criminal law also, they are governed by treaties. So one of the treaties which is very important and it helps in interpreting the international criminal law, and that is Article 31 Clause 1 of the Vienna Convention on the Law of Treaties. And it said that that treaty should be interpreted in good faith. Okay, and according to ordinary meaning to be given to the terms of the treaty. So even the International Criminal Tribunal of Yugoslavia applies this principle in interpreting its statute and treaties. Even you can relate this into just as we are certain of the in our constitution itself, we interpret certain statutes on the basis of justice, equity, and good conscience. So under the international criminal law, the treaty should also be interpreted in good faith. Moreover, you see that even the International Criminal Tribunal of Yugoslavia chambers have therefore relied on the primary object of establishing the tribunal, okay, and to punish serious violations of international humanitarian law committed in the former Yugoslavia and thereby to contribute to national reconciliation and the restoration and maintenance of peace in interpreting its statute. Even the trial chamber in Delali stated that the interpretation of the provision there must therefore be taken into consideration the objects of the statute and also the social and political consideration which gave rise to the creation. So it provides that while interpreting this the statute, um, just as in the first, you have seen that in the Vienna Convention on the Law of Treaties, the treaty should be interpreted in good faith. So, in the in a trial chamber in the law, it provides that the interpretation must be taken into consideration, or while interpreting it, we should take into consideration the object of the statute and also the various social and political consideration which gave rise to the creation. This is also very much important. Even the International Criminal Tribunal of Yugoslavia, like many other international and national courts, it determines the purpose of treaties through a teleological approach. It will apply a contextual rather than rigid or literal approach to interpretation. Okay, so it applies a very contextual rather than a very rigid or literal approach. Moreover, further you see that interpreting the purpose of the International Criminal Tribunal of Yugoslavia statute, it requires taking into account the fundamental purpose of the statute, most importantly, then you to ensure the fair and expeditious trials of persons charged so as to contribute to the restoration and the maintenance of peace in the former Yugoslavia. So you see that these are certain modes of interpretation of a statute, and there are various examples of methods which are used to interpret provisions of international treaties and other international documents which are listed below. Some of these methods are similar to those which are employed by the national courts to interpret the national legislation, and the extent to which the principles cited below may be relied upon in domestic courts to apply and interpret international treaties and other international documents. It may vary from country to country. There are various examples how we can interpret the provisions of a treaty. They are like first one is like that like cases are treated alike. That means what? The very title it suggests that the similar cases it should be treated the same and ideally with the same reasoning. So use like cases are treated alike. Okay, so this is the first, very first mode of interpretation. The second is that like declarations or advisory opinions are not given. So tribunals do not indicate in advance how it will interpret the rules and provisions. The third very modes of interpretation is that like in dubio pro reo, the version of a statute or a rule that is more favorable to the defendant it should be applied. Okay, a favorable condition to the defendant is provided. So the version which is like more favorable to the defendant it should be applied. The fourth very mode of like interpretation you see that policy considerations to aid the interpretation. Policy provisions may shed light on the purpose behind a particular provisions, but their use at the International Criminal Tribunal of Yugoslavia has been contested. So you see by interpreting the International Criminal Law, the policy provisions also helps in interpreting the statute. The fifth very mode of interpretation is that conflicting two or more official texts. In the Vienna Convention itself, in the Article 22, it provides that if there is a difference between two authentic texts, for example between English and Spanish, unless the treaty specifies which text should prevail, the version which best reconciles the text in view of their object and purpose it should be followed. And this very principle it is also reflected in Rule 7 of the International Criminal Tribunal of Yugoslavia. The sixth principle of international mode of interpreting the international criminal law is principle of effectiveness. So what is the principle of effectiveness? That a word should not be interpreted so as to make it redundant. Also, rules should not be made meaningless by restrictively interpreting other provisions of the same instrument. Okay, so this is the very sixth mode of interpretation. The seventh mode of interpretation is that presumption against lacuna. The gaps in international customary or treaty law it can be filled by reference to general principles of criminal law. However, the words that appear to have been deliberately left out of a provision by the legislative or treaty making authority, it cannot be read into the provision. So you see, like this gap should be filled by the general principles of criminal law. It is presumed. The eighth very principles of the international, you can say the mode of interpreting the international criminal law is adjustum generis. So, you know the meaning already. You have gone through this meaning, which means meaning of the same kind. And this is used to interpret loosely written statutes or legislation. This aid of statutory interpretation it should be used very carefully and only after precise legal definitions for provisions have been established. So this will avoid the violating the specificity requirements of the principle of legality. Okay. The ninth mode of interpretation is expressio unius est exclusio alterius. It means that to express one thing we have to exclude another. This generally means that if something is omitted from a statute or legislation, it is understood to be excluded. This aid of a statutory interpretation should also be used very carefully, especially while interpreting international criminal law provisions, where the inclusion of some very fundamental rights could be interpreted as the exclusion of other rights. So this mode of interpretation is also very important. The next mode of interpretation is your lex specialis derogate generally. So these are very native terms, terminologies which help in explain the new modes of interpretation of this international criminal law. So usually as according to the lex specialis derogate generally, if conduct is regulated by a general provision and a specific provision, then the specific which will prevail, the specific provision will prevail or it should prevail. The 11th very modes of interpretation is that Lura Novit Curia. This principle provides that it is for the court to determine the law and the parties to prove the facts. However, in the international criminal law setting, where the accused rights are at stake, this principle should not be applied, and the court can intervene when necessary to protect the rights of the accused. So, as favorable condition to the defendant, already which we have gone through. So, this principle should not, you know, this is the principle where the court can intervene when necessary to protect the rights of the accused. So this is one of the interpretation of the modes of interpretation of the international criminal law. Lastly, your last mode of interpretation is mandatory or directory construction. Even when a provision seems to be drafted in mandatory language, it can be interpreted as directory when that approach will best reflect the intent of the drafters. So these are the various modes of interpretation, like of the international criminal law. And so, one of the most important features of international criminal law is that, it should be interpreted on the basis of this, modes. Now, there is a relationship between international humanitarian law, human rights law, and international criminal law. As you know, this international criminal law is a subset of the international law it is related to, and so it is related to other areas of international law too, which including the humanitarian law and the human rights law. Indeed, both international humanitarian law and human rights law, it helped develop the international criminal law, and it continued to contribute to its interpretation and application. And the reverse is also true. Because you see, as we have already, I have already discussed to you in the previous lectures also, that this international criminal law, it has not been developed in the fullest form. It is still in a developing stage. It is still evolving. It has not reached its end. So definitely, this international criminal law, it's related to other areas of international law, which includes the humanitarian law, the human rights law, and it takes help, from both of them, and while developing it. So you see that international criminal law can be seen as an alternative to when states do not abide by the human rights obligations. Okay, so when the states do not abide by the human rights obligation, international criminal law comes into picture. So, what there are certain distinction between the international criminal law and the other bodies of the law. So the major distinction between the international criminal law and these other bodies of law is the fact that international criminal law, it deals with the individual criminal responsibility for violation of the international law. Okay, so most important thing which already have been, I think you all know, that international criminal law, it deals with the individual criminal responsibility unlike the other international law. Conversely, humanitarian law or the human rights law, it primarily focus on the actions and obligation of the states, governments, or parties to a conflict. So, this is the major distinction. That international criminal law, it deals with the individual criminal responsibility for the violation of international law, but the human rights law, the humanitarian law, the primary focus is in the actions and obligations of the states, governments, or parties to a conflict. Secondly, you see that this international human rights law and humanitarian law are very much related to each other. For example, you see the ICJ, that is International Court of Justice, it has held that the protection offered by Human Rights Convention does not cease in case of armed conflict. It said through the effect of provisions for the derogation of the kind to be found in Article 4 of the International Covenant on Civil and Political Rights. So they are very much related to each other. Moreover, you see, the laws and customs of war or international humanitarian law were created to protect the citizens during the armed conflict. And under ICL, that is International Criminal Law, various, violations of international humanitarian law are now considered to be war crimes. However, the two bodies of law have distinct modes of interpretation and application, and while international humanitarian law it can be useful in interpreting the international criminal law, the two should not be conflated. So you see, though there are distinctions between the international criminal law, the human rights law, and the international humanitarian law, but they are mostly related to each other. So in particularly, you see that international humanitarian law is broader than international criminal law, and not all violations of international humanitarian law constitute the war crimes. And in addition, not all international humanitarian law it treaties the criminalize international human law treaties it criminalize the violations. Although the violations may be classified as war crimes through customary law. Moreover, you see that the international humanitarian law is primarily addressed to states and parties to the conflicts. And international criminal law, on the other hand, it is addressed to the individuals involved only the most serious crimes and violations which can result in the criminal liability and penalties such as imprisonment. So there's a certain major distinction also, and there's a relationship also. Moreover, you see that international human rights law, it is designed to protect the basic rights and freedoms of all persons, and it's based primarily on treaty law. And to a large degree, this international criminal law it developed as a response to mass violation of human rights by states against citizens and persons within their territory. Okay, and the prosecution of the genocide and the crime against humanity it developed from the human rights standard. In that human rights law, it influenced the drafting of the statutes of international criminal tribunals, and judges at these courts have used human rights law to interpret the substantive international criminal laws and procedures. So you see how there has been a development of the international criminal law taking help of the international humanitarian law and also the human rights law. So this human rights law also influenced the drafting of the statutes of the International Criminal Tribunal. And judges of this court, it used the human rights law to interpret the substantive international criminal laws and procedures. However, you see that international human rights obligations, they are primarily imposed upon states, not individuals. The states must decide for themselves how to enforce human rights obligations and deals with the human rights violations by state agents. Moreover, you see, not all human rights are protected by the international criminal law. International criminal law can be seen as an alternative to when states do not abide by the human rights obligations. So you see that though there is a distinction between the international criminal law, international humanitarian law, the human rights law, but still there are certain there is a relationship which exists between the three. They are very much interrelated to each other, and all of them help in developing their own spheres. Because international law is in a whole, you cannot say that this is totally developed. It can be the international migration law or international humanitarian law, or you can say the international criminal law. It is not developed in its own form. So these are the this is the basic relationship between which exists between the international criminal law, the humanitarian law, and also the human rights.